Hello everyone, this is your instructor Elizabeth Floyd, and I'm going to lecture on the material found in Chapter 8 of our textbook, Juvenile Justice. It would be wise for you at this point to pause the lecture and print out a copy of the PowerPoint before you go any further. You will find it helpful to be able to take notes on the PowerPoint as you listen to this lecture. This slide shows the lesson objectives. These are the things I hope you'll be able to do by the time you've read all of Chapter 8 and listened to this lecture. Again, I cannot emphasize enough the necessity of reading your textbook, especially now that we're not able to discuss it in class. You really must read this material in order to understand it and do well with it. But either way, when you're done with your studies of Chapter 8, if you go back and look through these objectives and make sure you can do all 5 of these things, then you'll be prepared for the Chapter 8 material on the exam. So I want to start out here with just an introduction to juvenile justice. And I've got a couple of slides that are going to show some statistical trends. The trend here that you can see, this is a line graph that reflects arrest rates, and it divides them up by age. If you look at the x-axis here, it lists the rate of arrest by age, and then it divides up the type of offenses that the arrest was for, the dotted line being all offenses, the purple line, crimes against property, the teal line, crimes against persons, and the green line, light green line, being crimes against society. Those are mala prohibita offenses such as prostitution. And what you're going to notice pretty obviously here is that the offenses, all offenses, are most likely committed by juveniles. The highest arrest rates are in this age group, 11 at the onset of puberty through age 21 or 22. So the juvenile teenage years, those aged people are disproportionately more likely to be committing all crimes. Now you will see a slightly higher peak in offenses among property offenses. So juveniles are mostly responsible for property offenses more so than crimes against the person. There's less of an arc here for crimes against person. They are disproportionately more likely to be the ones committing crimes against property. But still, most crimes are committed by juveniles. And we'll get into the why of that further, but I wanted to point out also 2 things. First of all, this data is not unique to our country, to America, or even to Western Europe. This is true all over the world and for all of time. There's nothing unique about it. It's something that scientists have noticed and observed crosses all geographic lines and all timelines. This has been true for all of time and everywhere in the world. So there must then be something about the juvenile years that has this propensity for criminal behavior. The second thing I wanted to point out is the words statistical trends at the top of this slide. That's a hyperlink. If you want to click on it, you'll go to a reliable website that will provide interactive data and graphs where you can look more specifically and see differences, gender differences, and differences between the types of crimes. It's interesting. It's not something you have to do, but it's available if you want to. So let's go on to the next slide. Remember now, most crimes then are committed between the onset of puberty and adulthood. So what is it then about juveniles that makes them so likely to commit crimes? Well, plenty of smart scientists have thought about that, and what they've discovered is 2 things. If you look at the image here on this slide, it's a image of the human brain and what it looks like from age 5 through age 20. And you can see a marked difference in the volume of gray matter in the brain. Now, I am not a physiologist, but my understanding is that gray matter is the mature form of brain tissue where systems are interacting properly. All the connections are there. That's the mature brain. So you see how much maturing goes on between these years structurally within the brain. So what else is going on in the juvenile years? The obvious, hormones. They are raging. So at this time period where the brain is structurally immature and you've got hormones going nuts, what the result is, juveniles are not able to understand the consequences of their behavior. They have a messed up reward system and they don't understand the danger that they're facing and the harm that they're causing others. So without that level of maturity, well, sure, they're going to have a propensity for criminal behavior, unfortunately. Now, this is not all juveniles. I'm sure you all were perfect angels and never did anything wrong. But what I'm emphasizing here is this is why juveniles are disproportionately committing criminal offenses in our society and in all societies. That's the nature aspect to it. I wanted to throw in that nurture plays a role too, and that has to do with the home life. The socioeconomic condition of individuals will most certainly contribute to their likelihood to be involved in criminal behavior. Before we go any further, so still with the introduction, please note when we're talking about juvenile offenses, there are two types: status and delinquent. A status offense is an offense that is illegal because it is committed by a juvenile. It would be perfectly legal for an adult to do, but it's not legal for a child or a teenager to do, such as underage drinking, skipping school, running away from home. Those are status offenses. They're wrong because they're committed by juveniles or teenagers. On the other hand, delinquent offenses, that's behavior that is a crime regardless of who's committing it. That's your murder, rape, theft, robbery. So when we're talking about a juvenile delinquent, we're talking about a juvenile who has committed a crime that would be a crime no matter their age. When we're talking about a status offender, we're talking about a juvenile who's acting out. And the reason this is important is because our justice system treats them differently. Status offenses are usually diverted out of the justice system and the juveniles are returned home. Likely they're going to receive counseling, community service, some sort of intervention just to help them get back on the right path. A juvenile delinquent refers to a juvenile who's been adjudicated guilty of committing a crime. And they are handled with some sort of detention, fines, and other things that would be used to punish an adult as well. Okay, so now we're going to get into the second objective, and that is the history and philosophy of juvenile justice. First, I want you to recognize that there are three things that have had the biggest impact on the way our society has treated juvenile delinquency. And those three things are our cultural perception of childhood, immigration, and poverty. So I'll connect in immigration and poverty in a little bit. I want to start out with the way that our perception of childhood has affected our treatment of juvenile delinquency. So to start out with, and I'm going way back in time, folks, like the 1st, 2nd, 3rd, and 4th century. And during those times, we used, or the philosophy that our society had of childhood was called patria potestas. So that's a Latin phrase, patria potestas. I may not be pronouncing it right, but it doesn't matter. What it means is fatherly power. Children were considered the property of their father. Okay, their father had in all full, complete control over what happened to their children. The father, therefore, was entirely accountable for the behavior of the child, and the father had the sole authority over their punishment. So if a child got caught stealing, he'd be returned to his father. His father could do whatever he liked to him. Beat him, lock him up, whatever. That was the way the world worked. And this is ancient Rome, 1st, 2nd, 3rd century, a long time ago. The father had complete and utter control over the behavior of juveniles because the juvenile was the property of the father. That lasted till about the end of the 4th century in Rome. And at that point, you start to see I guess, a little bit more of a gentle influence coming into play. This is a time period where our philosophy or perception of childhood would have been described as paterna pietas. It's another Latin phrase that means fatherly love. So there, you're looking more at a time period where fathers were allowed to show emotion, to care for their children, to see them as separate human beings worthy of love and nurturing. So there were at this time some limits placed on the father's authority, but not a lot. But then we come into the Middle Ages. And during the Middle Ages, the church, predominantly the Catholic Church, had a significant amount of power over government and our justice system. And as a result of the church's influence, our justice system developed a rubric of sorts on how we're going to deal with juvenile behavior. And the rubric was, from infancy through age 7, a child is a child. And they are not responsible for their actions. They don't have the maturity to make good choices anyway. So they'll be reprimanded at home, guided, loved, and helped to grow up and learn from their mistakes. The second part is ages 7 to 14. And that's sort of this state of flux. Well, kind of depends on the child, whether we're going to consider them fully culpable for their actions or not. But at age 14, that was for some reason the mark, the threshold point at which an offender was fully culpable for their actions and would be punished the same way as an adult. So that's a very strict, almost arbitrary rubric based on the specific age of the child as to how we're going to perceive their criminal culpability. And that stayed in place for a very long time, and it is even still influential in the way we treat juveniles today. But during that time period, a new philosophy of childhood emerged that is known as parens patriae. Parens patriae is just the Latin for state as parent. And guys, this is the 13th century. The state is the king. Okay, so we're talking about the king is the parent. So the king would be the parent of all his subjects, including children. Therefore, the king would be able to intervene in juvenile discipline. He would be expected to act in the best interest of the child and take authority over the parent in determining what type of punishment should be administered to the child. Obviously, the church is still very powerful at this time, so this rubric is in play as well. But here we have a time with where the government now can intervene in the discipline of children. It's not just up to parents. So what we'll see then is the emergence of institutions to deal with juvenile delinquency. And it started out, I don't have it written on this slide here, but it started out with a sort of process that was called binding out. So binding out was a means of juvenile punishment. Children who were found delinquent or whose parents really just couldn't afford to take care of them could be given over to another family, usually as an apprentice. So the notion was, okay, the child is a delinquent and is misbehaving because they don't have anything to do. They're not going to be in school necessarily, or they're poor, they don't have opportunities. So let's put them to work. So idle hands are the devil's handiwork, right? Or the devil's playground, I think the saying goes. So get them busy. Give them something to do so that they won't be delinquent anymore. So they'd bind them out to another family and let them work and learn a trade. And that worked for a while. As you move into the 1800s, though, actually, no, this is the 1500s more so, you saw a development of something called workhouses. If you're familiar with British literature and Charles Dickens, you've heard the word workhouse before, and you know it's a place where orphans wound up often. Bridewells were the names given for juvenile workhouses, and they were just places, so instead of apprenticing children out to individual families or to foster parents, now you're going to see them being put in these bridewells, these institutions where they are required to work and learn a trade. Unfortunately, whenever you take children and you put them into an institution, you have a terrible consequence, which is abuse and mistreatment often occurs in these situations, and it definitely occurred in the bridewells. But that's what was done for a significant period of time, beginning about in the 1500s and rocking along even into colonial times. So the Western Europeans brought their philosophy towards juvenile delinquency to America, and they brought along the notion of institutional control. Only when you get to America, it's given a different name. So in America, you're going to call it a house of refuge. Sort of euphemistic, right? Refuge, like it's a safe place for children to go. In the 1800s, I believe that's where you saw the first houses of refuge. Yes, 1832 on the picture here. That's the New York House of Refuge, a depiction of it anyway. You see this nice garden out front where you might at that time have seen children working. So a juvenile delinquent is snatched up off the street and sent to a house of refuge where they're given a trade. They may be educated. The idea is that we're going to educate them, we're going to put them to work, and therefore they'll recover from their delinquency and emerge as a productive, law-abiding citizen of the U.S. Unfortunately, again, there is a downside. That is abuse and mistreatment. But what you want to notice here is so now I mentioned the cultural perception of childhood has a direct relationship with the way we deal with juvenile delinquency. But here comes the interplay of poverty. So the children that were being put in these houses of refuge were poor children. And the offenses they were responsible for: begging, pickpocketing, vagrancy. They're hungry, they're starving, and they're homeless, and they have nowhere else to go and no other means to provide for them to get food. And the high society folks see these poor orphan children in the streets begging for money, and they don't want to see them there. And so out of sight, out of mind, right? You call the constable, he comes and takes the child, puts the child in a house of refuge. You get them off the streets. You educate them, teach them a trade, and the idea is you're going to reform them by putting them in these houses of refuge. But you're also putting them in a place that really, in some instances, was a place where there was a good bit of abuse. They were definitely not perfect places. There was also immigration influencing this treatment of juveniles as well, because in the 1800s came the influx of immigrants to go to work in our industries. This is the Industrial Revolution, and you have massive amounts of immigrants coming from, at first, I believe, Western Europe, then Eastern Europe, and they're coming in to work in the mills and the factories until we have this economic depression that hits, I believe, around the 1840s, if I've got my time right. So with this economic depression, these immigrant children, they lose their jobs, and now they're out on the streets. So you have an influx of immigrants who come to work, then they lose their jobs, and they wind up on the streets of New York and Chicago and Washington, D.C. and Philadelphia. And the crime rates go up, and these houses of refuge emerge as a place to put these juvenile delinquents to reform them. That works for a while until, I say works. It was certainly not a perfect situation. But towards the end of the 1800s, with the progressive movement, the poor conditions of these houses of refuge is finally acknowledged, and something is done about it. It's not perfect. Groups such as the Child Savers, that was an example that the textbook gave, but there were other groups too. They believed, okay, these houses of refuge, these reform schools are not really working. We think it would be better for them to go and be placed with a family again. And not just any family, but rural families. So we're going to send them out of the cities, no longer in these houses of refuge. Now you're going to go out to these farm families, out in more rural communities where they'll be provided not just with a trade and education, but also moral development. The expectation is if we give these kids some religion, they're going to do better. They're going to develop into more mature, responsible, law-abiding citizens because they'll have this Christian upbringing by a loving family who lives on a farm somewhere out of the city. So that was just an effort to provide some reform to the institutional model that we had been using before. That wasn't perfectly successful, and over time, what developed were our modern day or more modern juvenile justice system with detention centers and the like. I believe the first one was in 1899, maybe. You'll have to check the textbook for that. I think it's in Chicago, was the first separate juvenile justice system emerged in the early 1900s with the progressive movement. There was an effort to bring in this differential treatment for juveniles, to give them their own justice system. I'm going to go back a slide here. You'll see under cultural perception of childhood generally, I've noted a case, Ex parte Krause. That was the point at which the American justice system overtly adopted the philosophy of parens patriae. So no longer king as parent, state as parent. Now, state, local governments would be looking out for the best interest of children. And that became part of the practices of these new juvenile justice systems, that parens patriae influence, philosophical influence on the way juveniles were going to be treated in the juvenile justice system. By 1945, though, all states in the U.S. had their own separate juvenile court system. And these juvenile court systems were providing the parens patriae, applying that philosophy, trying to intervene and seek the best interests of the child. But it was somewhat arbitrary. A judge had all full discretion on what he was going to do with this juvenile that was in front of him. And there were no rules in place that dictated, what punishment would go with what crime. There weren't procedures for holding the judge accountable to be consistent and to be fair. There was no due process at all early on. So you have this, what the book called unbridled discretion vested in judges for the handling of a juvenile offender. So the idea, though, okay, we're giving him latitude so that he can look at this child as an individual and do what's best for this specific child in this specific circumstance. And that sounds good, and the intentions were good. But what it worked out as was a lot of inconsistency and arbitrariness. And the sentence that a child might receive could be a rather long stay in a detention center. That's a loss of liberty, the same way a prison sentence would be. The child is losing their liberty for a significant period of time, and there is no due process whatsoever applied to that adjudication. So that there's the upside and the downside. The upside is, okay, we're looking out for this specific child. Downside is we're not giving the child any of the due process protections that are normally provided when someone's going to lose their liberty. And that's what we move to with our next slide here. It didn't go on forever. The Supreme Court took notice of the inconsistency and somewhat arbitrary treatment of juveniles. And beginning in the 1940s, you see a series of decisions from the Supreme Court that began to extend due process protection to juveniles. There's several cases that are listed in your textbook, and I do not expect you to memorize all the cases and what the court held and what the rule was. What I want you to notice is the slow progression of giving due process protection to juveniles. And even over, 30, 40, 50 years of these decisions, extending more and more due process protection for children or juveniles, they don't wind up with all due process rights. So even today, juveniles do not have the same due process rights that adults would. There are many, but it's not the whole thing. Juveniles are still treated differently than adults are, and there's a reason for it. So going back to the slide here, we still have, modern day, we still have parens patriae as our philosophy. State as the parent looking out for the best interest of the child. But we now have more formal rationality. If you think back to Weber's types of decision making, substantive, rational, irrational, substantive, formal. So we've developed now with our judicial justice system for juveniles, we've developed into the same sort of formal rationality that our adult justice system has, with some exceptions. So we have some predictability, we have some consistency. It's very systematic now. There is a rehabilitative focus that I'm sure you're aware of just from being alive. We are looking to reform and rehabilitate a juvenile more so than we do for adults. The newest trend now is to apply a system of restorative justice. We'll get to that in a little bit. And I've included on this slide a link to South Carolina's Department of Juvenile Justice. If you click on that link, it'll take you to their website, and it is very informative, and it explains the formal, rational, systematic procedures that are given to juveniles who are brought into the system. I want you to I've got this slide, the next slide here, list what due process rights are and are not granted to juveniles, and I want to go through them. The big case, the one that listed many due process rights that are going to be afforded to juveniles, was In re Gault in 1967. I've written that at the bottom of this slide. You just want to keep in mind that that was sort of the pivotal decision where the Supreme Court said, you know what, we've got to give juveniles due process protections similar to what we give adults, because these adjudicatory hearings often result in a loss of liberty, and we've got to give them at least some or most of the due process protections that we're going to give adults. So that case, In re Gault, is responsible for providing juveniles with the first 5 due process rights in our list. Notice of charges against you. So juveniles are given notice of their charges against them just like an adult. Juveniles have a right to counsel at any critical stage in the adjudication process, just like adults. They are permitted to confront witnesses and cross-examine people who are testifying against them. They have the privilege against self-incrimination. They can remain silent, just like an adult can. And they can appeal. If the adjudication process finds them guilty and labels them as a juvenile delinquent subject to a sentence, they can appeal and raise the case up with the appellate courts and the Supreme Courts and so forth. Later decisions gave them the due process protection for the burden of proof. So before it had been something like preponderance of an evidence, but as of that particular decision, which was, In re Winship, so this was in 1970, now the prosecutor in a juvenile proceeding must prove their case beyond a reasonable doubt, just like in an adult case. A later decision gave them double jeopardy protection. And then a very recent decision, this is in 2005, Roper versus Simmons. There the Supreme Court said juveniles under the age of 18 when they commit their offense cannot be put to death. They cannot receive the death penalty. Now that is a protection adults do not share. That is unique to juveniles and also to the mentally incapacitated individuals. So in 2005, that was one of the last decisions pertaining to juvenile justice, and it protects them from a sentence of death. Now there are several other cases. You might want to look through your textbook and be familiar with them. But the point is, these are the rights that are afforded to juveniles. They are different than the rights that are afforded to adults in some ways. If you look at the right column on the slide, there are still some rights that are not purposefully not granted to juveniles. That's the right to a jury trial and a right to bail. And there's a reason for that. You think about a jury trial. Jury trials are public. We protect the identity of juveniles. We don't want their adjudication public. Juvenile records are sealed. So this is a private proceeding. We don't want their whole life ruined because of some stupid mistake that they made in their teenage years. So we seal their record and they do not receive a jury trial. It's still just a judge who is deciding the case of whether they are guilty of committing a crime or not. And they are not necessarily going to be afforded bail in every instance the same way that an adult would. It would be handled differently because you've got parents involved who are often able to, well, not all, I don't know often or not, but sometimes able to take custody of the child and look after them. But there is no guaranteed right for bail to have the children post bond and be able to go home. They can be held in a detention center pending their trial. I'm going to go back a slide real quick. You see here juvenile waiver into the adult system. I believe I have a slide later on. Yes, here I go. Okay, I can move forward a slide. Juvenile court versus adult court. What I'm talking about here is the waiver process. The waiver meaning, is the child going to be dealt with in the adult system, or are they going to go into the juvenile court system? That's the determination that has to be made at some point whenever there's a juvenile offender. And it is pretty state specific. It's going to vary by the jurisdiction. It'll be one of these though. It will be, there will be either a statute that says for this offense, the offender will be dealt with in the adult system, but for this offense, it'll be dealt with in the juvenile system. is often also determined by age. So you can have a statutory mandate that orders the decision of waiver or not, where the juvenile will be sent for adjudication. There can also, the decision to waive can also be dealt with by the judge at his or her discretion, or the prosecutor. In some instances, like the county solicitor in Greenwood has some discretion over whether to waive a child into the adult system or not. Actually, South Carolina, I've got on here, has a combination. There are statutory mandates. The statute itself says, in these instances, the judge will have discretion to waive. And then there's a statute that says, in these situations, the prosecutor will choose whether the juvenile will go into the juvenile system or the adult system. And then there are some offenses that just flat out, that at this age, I believe it's 16 or so, they will be handled in the adult system. But if you go back and click on this link to South Carolina's Department of Juvenile Justice, you'll see there's a description of the statute that describes the waiver process. But what I want you to take away, though, is that it is very state specific, and it will be one or more of these things: statutory mandate, discretion of the judge, or discretion of the prosecutor. And look here on this slide, I've got a map of South Carolina's juvenile court system. You see down at the bottom left, dismiss or divert. Okay, so divert means they're out of the juvenile justice system. If I understand this correctly, what we're talking about is status offenders here. A status offender is not going to go through the adjudication process that's above. They'll just be sent through some sort of diversionary program that's described on that website, specifically for status offenders. Okay, so the last thing I want to talk about, I'm going to go back here. I say here, talking about our current juvenile justice system, restorative justice. That is the newest trend for dealing with juveniles. That's the modern mechanism for it. And I want to spend a few moments talking to you guys about that. Restorative justice operates in what has been called, at least by your textbook, a balanced approach. So we're going to do things a little differently with juveniles. We're going to be more balanced between these three things. So if you look at the circles here, you see the word victim. Here's another circle, offender. And at the top, the circle says community. And it looks sort of like a Venn diagram where these circles are overlapping. And in the overlapping part, you have something called restorative justice. So restorative justice is trying to integrate the concerns of the victim, the concerns of the offender, and the concerns of the community in a system of justice for juveniles. And what it does is seeks to hold, first of all, now you've got this triangle laying on top of it, it's going to hold the offender accountable. So there's accountability. And they're going to be held accountable to the victim, and the victim's wishes and concerns are addressed. This often takes place in the form of a mediation, where the offender must face his or her victim and listen and hear the harm and experience of the victim, hear the pain that they felt or what they suffered by the hands of the offender. And that is meant to help the offender realize the consequences of their actions. So if you remember at the beginning, I was talking about the difficulty that teenagers have with understanding the consequences of their choices. Well, here we are in restorative justice trying to teach them the consequences of their actions and see how their choices can deeply, deeply harm the victim, and to listen, see the tears, see the anguish on their face, and know what they've done, fully know what they've done. That usually results in some sort of mediated punishment, where, okay, they may write a letter of apology to the victim. They may perform some community service. But there's also the possibility of detention. So loss of liberty can still come into play here. And that's where you're taking in taking in the concerns of the community and community safety. So, we're not going to just send them right back out on the streets. Even in the course of restorative justice, which has this rehabilitative angle, we're still going to protect society from the potential for additional crime being caused by this offender. The third and final aspect of it is called competency development. And this is more about education and prevention of juvenile crime. This is where communities would have like a Big Brother, Big Sister program, or an after-school program, or your YMCA programs that are meant to keep kids active and involved, playing sports or some sort of activity that keeps them busy, keeps them learning, and allows them to have a safe place with good influences, and is sort of to prevent them from falling into a life of crime. And that all is connected into this system of restorative justice. So if you go and look at South Carolina's Department of Juvenile Justice website, you'll see that South Carolina is pretty progressive as far as juvenile justice goes, and they do have restorative justice programs. I don't think they're called restorative justice. They have different names, but they are applying the same philosophy. So that brings you up then to the modern day juvenile justice system, and I hope you've seen the history and how it all developed over time and came to be what it is now. I'll go back very, very briefly to the objective slide and make sure we've covered all the terms and concepts. Okay, yeah, so the difference between status offenses and delinquent offenses, the philosophy of parens patriae, we recovered that. The institutional model, the way institutions were used to deal with juvenile crime, the progressive movement's influence, waiver, restorative justice. Yeah, we've covered all of that. So if you have any other questions, please email me. I'm glad to answer your questions by email. If you'd like to speak to me in person, I can hold a Zoom call with you one-on-one and go over any questions that you have. At this point now, if you've read the textbook and you've listened to this lecture, I want you to go into Blackboard and look under the Exams and Quizzes tab. I'm going to, I should have, by the time you're listening to this, posted a short quiz on Chapter 8 that you can take, and in fact, I want you to take so I can see how you're progressing. Take the quiz, and if you get them all right, then you know you're in a good position. Doesn't mean you should not study further, but it does mean that you've understood some of the main points of the chapter in this lecture. Hope you guys are staying healthy, and please reach out to me if I can help you in any way. I'm here to do that. I miss seeing you and being able to talk to you in person. So let me hear from you if you need anything.